AG's office in county.
Wait.
But this whole we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on here?
Today's case takes us to Ingham County, Michigan. The defendant, Carlos Lee Anthony, faces 5 felony charges, including assault, fraud, and 3 counts of armed robbery, which carries a possible life sentence. But after a series of delays, including the defendant's failure to appear, the case has now been in the system for nearly 4 years. So Circuit Court Judge Rosemary Aquilina looks to move things forward and asks the prosecutor whether a plea offer has been made yet.
No, there has not been a plea offer made in this case. In discussions with the defense attorney, it was made clear that the defendant would only accept a misdemeanor, so there was no real negotiation beyond that.
Counsel?
First of all, I don't discuss the subjects of our negotiations. We had a conversation. I don't know that I ever said that he would accept any offer, let alone whether it's misdemeanor or felony. In this matter, he maintains his innocence, and we've negotiated as such. Where we're at right now is Mr. Dovey had indicated to me 3 months ago that he was going to follow up with law enforcement about getting discovery that's outstanding, and I haven't heard anything since. We don't have the body cameras, the motor vehicle camera videos, anything of that. I understand this is the AG case was transferred to the AG's office in Ingham County.
Wait.
But this whole we don't have it.
Stop a minute. This is a 23 case. Sir, how is it this information has not been given to counsel? 2 years, 3 years. What's going on here?
The problems don't end there. This is a final pretrial where both sides are expected to have already completed discovery. But Prosecutor Michael Doby says the detective sergeant recently located additional evidence, and it turns out this evidence may be crucial to the defense's case.
4 body cams that had not been previously provided to my office were provided. They have been provided via a download link to Mr. Berry.
Via what? Via what?
A download link, a link to download.
Download link? Okay. So, is there outstanding evidence that you have not provided to defendants in 3 years?
No.
Are you?
Well, frankly, Your Honor, I'll have to talk to Mr. Doby to find out when this stray email must have been sent for me to download some additional body camera. It's interesting. I'm being told that much of it doesn't exist, which what I'm asking for is body cameras and dash cameras. And then in the same vein, being told 4 body cameras are sent to you. I don't know. I guess I'll have to look at them. But I know there's lots of law enforcement that were involved with this. They're referenced in the police reports. And to be simply told they don't exist, I want to get some follow-up on here. I guess I'll have to file a motion to compel, and we can get evidence.com records to prove whether or not they exist and what efforts Mr. Doby has taken, if any, to actually retrieve them.
Okay, I have a solution here. And Court of Appeals is down the road if neither one of you like it. So today is the, 26th? No. Yeah. My brain's already finished. Today's the 28th of January. Whatever's outstanding or whatever, can this be figured out by February 4th?
Oh, not that quick.
Why not?
Well, I currently have another.
Don't care. Because they have to come up with it, not
okay,
you.
there's only one me, and I have lots of words.
I know you do.
So
I know
that quick, I cannot.
Wait a minute. You have a list of what you need, right?
Yeah.
Okay.
Well, I mean, I don't know what exists. By all police.
Not your job.
Yeah.
Not your job. Sir, turn over everything that exists.
Yes, Your Honor.
You can go through, it's going to take 10 seconds. You could do it right now. I'm happy to wait. You can go through your email on your phone. Just don't say anything yet. You can go through your email on your phone, whatever, and look. And if you never received it, I'm inclined to dismiss this.
Well, that part we clarified.
Okay.
He gave me back in November a download with 172 files. We had a screenshot,
Okay.
and I confirmed with him that I have downloaded those, and that even in his own material, that those do not include law enforcement recordings.
A routine final pretrial quickly turns into something far more serious. The court learns this felony case has been pending for years, yet critical evidence still hasn't reached the defense. As both attorneys explain conflicting accounts of missing body camera footage and discovery records, the judge's frustration becomes impossible to ignore. Every answer raises another question about how such an old case could remain so unprepared. Instead of moving toward trial, the hearing exposes deeper concerns about accountability, fairness, and the prosecution's handling of evidence. With tensions building on both sides, it's clear the courtroom is heading toward a decision no one expected.
He's at least providing an update that there apparently he found 4 police videos. I don't know. He's never emailed or communicated with me about that. But if there's a download,
when did you find those 4?
I'm sorry, I didn't find them. The detective sergeant now, I have no access to evidence.com or whatever the Lansing police use. But the additional 4 videos, so the entire reference 176 items. So sending everything again was sent this morning to Mr. Barry, like within the last half an hour.
So the 4 additional cameras were sent this morning, and I've received no additional information. Okay, now I understand.
Okay. Let me understand.
They didn't exist before this morning, apparently, Your Honor.
Representing Mr. Anthony is attorney Ronald Barry, who, along with the judge, expresses frustration at why the prosecution is slow to provide key evidence in a case that's this old. When Doby explains that additional police videos were only just located, Judge Aquilina makes it clear she finds that explanation troubling. What follows is a tense exchange that will play in full.
Here's what we're doing. This case is dismissed.
I'm sorry, Your Honor. There's been no motion to compel. There has been. You're dismissing these because only because
dismissing these, so you
Mr.
go
Barry
and get your
says
act together and you can reissue it. This file is 3 years old. This man is due a speedy trial, and this information is not new. I rarely do this. I can't think of one time in 22 years I have done this, but this seems to me to be unfair and prejudicial, and you can reissue. You can take your time and reissue when everything's put together, and then we're going to do all this again. And am I causing taxpayers money? Yes, but you know what? This man has been reporting to pretrial services for 3 years. The date
Your Honor,
of this offense
respectfully, he is not.
Respectfully,
This
if
has
you
been on
interrupt
2
me again,
years.
you will be picked up and put in lockup for contempt. So I'll give you a chance to talk, but you will not interrupt me, especially when you're on Zoom, and I've given you the courtesy to not plow through the snow like everybody else, and you're on Zoom. This offense occurred February 15th, 2022, and I am not a judge who just dismisses things lightly. And you can ask everybody in this town, you can go down to the Court of Appeals, and you can do whatever it is you want. But this man has been under our charge for 3.5 years or so, and things have not been turned over until now. And now I'm hearing they need more and more time. There's constitutionally protected rights. When you all get your, and there's no statute of limitations on a life offense. So when the Attorney General gets their act together, so will everyone else. This is dismissed for lack of progress and prejudice.
Your Honor, I need to make
Court of Appeals down the road. Yes?
Can I make a record here, Your Honor?
You can make whatever record you want as long as it's respectful and don't interrupt me again.
Absolutely. Thank you. Yes, Your Honor. This case was charged by the Ingham County Prosecutor's Office. It was almost a year before
you
the
have to stay,
AG.
Sir, it's my court reporter. You got to stay near your microphone. The Zoom, for whatever reason, is not picking you up very clearly.
Thank you, Your Honor. This case was originally charged by the Ingham County Prosecutor's Office. It came to our office approximately a year after that. For about a year and a half since I've had it, the defendant was on bench warrant status, not reporting. He is, despite repeated violations before and after that. I don't believe that there is any basis. I don't believe that there is any basis for dismissing this case.
It dropped after bench warrant status.
He was on bench warrant status, not reporting.
Yes, Your Honor. He was on bench warrant status following a violation. He was just on the idea that he has been reporting to pretrial services for 3.5 years. That's not accurate.
Well,
I don't believe that there is any basis for this dismissal based on the defendant.
Sir, you gotta start again. The court reporter's not picking it up.
Your Honor, I don't believe that there is any basis in law for this dismissal based on the defendant's claim that there is additional discovery that has not been provided.
Sir?
The hearing reaches its most explosive moment after learning that additional police videos were only recently discovered. The judge concludes that years of delays have placed the defendant's constitutional rights at risk. The focus shifts from missing evidence to whether the justice system has failed to move the case forward fairly. As the prosecutor tries to defend the record, emotions rise, an interruption earns an immediate warning, and the courtroom atmosphere becomes increasingly tense. Then comes a stunning ruling that halts the prosecution and leaves everyone scrambling to respond, proving that preparation can be just as important as the charges themselves.
There's been no order to compel, no motion to compel, and no showing that there's been any wrongdoing by any party here.
Okay. The bench warrant that I have was in 2024. We are in 2026. The first witness list that I have here from the people was in 2024, August of 2024. This is a final pretrial. My expectation on a final pretrial is that you are all ready, not that we go back to square one like when he was charged. And you certainly can file a motion for reconsideration or do whatever it is you want to me, but this is truly unconscionable here. In August of 2025, he was held in contempt and served 17 days. So between August and now January, there was plenty of time for this evidence and the files from both sides to get in order. I don't know why we're at final pretrial and now there's claims of things that have been in possession of law enforcement and the Attorney General, and I suppose the Ingham County prosecutors for all these years and not been turned over. So as far as I'm concerned, a lack of progress is violating a fundamental right to presumption of innocence and freedom. And believe me, I don't do this lightly. I understand these are life offenses. They're very, very serious. But so is the lackadaisical attitude, maybe on both sides, maybe on all sides. I don't know, but I'm not going to stand for it. The resolution is to either file a motion for reconsideration or simply recharge defendant. No, we're done with this file.
Your Honor, may I ask the court issue the order so I don't have to worry about an objection, 7-day rule and all that?
There's one right there, print it. We'll send it over to him and I'll sign it. Just do the blank one. I'm not, so sir, I suggest, you're not skipping town, you got another file in front of me. I suggest that you are the most law-abiding person on the planet. I don't like what happened here. I don't like these charges. I don't like this whole situation. But you do have a right to a speedy trial and a right to have an exchange of information that is timely. And this is simply disturbing. And I know everybody's busy. No one knows that more than me. And I had 100% criminal docket. I get it. But this speaks to laziness on your part, your counsel's part, the prosecutor's part, the Ingham County prosecutor's part, and that's not a justice system. That's a lazy system. That's not what I'm going to tolerate. So message sent, they may very well reissue. So I suggest that you deal with your attorney and maybe you continue working on this. I really don't know. I'm not giving you legal advice, but they do have the option of reissuing this immediately, and they can do that. But message sent, I hope. That is all. I'm going to sign the order. We're going to, counsel's writing it. We're going to send it to you, sir, for approval, or I'll just read it now on the record.
Yes, Your Honor.
All right, this matter is dismissed without prejudice for the reasons stated on the record. Any objection to that, counsel?
No, Your Honor.
On behalf of the Attorney General?
None beyond what I've already stated.
Great, send a message to your office. I expect timeliness, especially on a final pretrial. You all get your ducks in a row or this will happen. I don't know what else to say. I have not done this in 22 years. But this does not sit well with me. Well, make sure you all get a copy of this. That's all for this record.
Thank you, Your Honor.
Counsel, you have a next date on the second file? I hope.
I believe there is one, yes, Your Honor.
All right, thank you.
Even after the unexpected dismissal, the hearing isn't over. The prosecutor continues arguing that the ruling lacks legal support, but the judge remains focused on the years of delay and the failure to have the case trial ready. She emphasizes that serious criminal charges do not excuse poor preparation or late disclosure of evidence. Although the case is dismissed without prejudice, leaving the door open for prosecutors to file the charges again, the judge makes it clear that the message is about accountability and protecting the integrity of the justice system. The hearing ends with a warning that future cases must meet a much higher standard. If you enjoyed this courtroom breakdown, don't forget to subscribe, and turn on notifications. We'll see you in the next video.